The petitioner will start the divorce case by filing the petition packet in their county's family court. This packet includes 3 documents: the petition for dissolution of marriage, which says, I want a divorce or I want a legal separation or nullity, the summons, and if you have children, the UCCJEA. These forms can be found online at the California Court webpage and in this course. Also, make sure to check with your county for any local forms that need to be included with your petition packet. The first form in the petition packet is the petition, FL-100. The petition gives you an opportunity to request orders in your divorce and state your position on those issues. Mark every issue that applies to you, such as property division, child custody, child support, and spousal support. You have the option to provide more details using the other FL forms as attachments. However, you're not required to provide the details in the petition. And none of what you mark on your petition will actually take place when you file or serve your spouse. But the petition is important because it gives the judge the power to decide your case or make court orders out of the agreements you reach with your spouse. You need to check the box for every issue in your divorce to give the judge that power. If you made a mistake but filed the petition, you can file an amended petition by checking amended at the top of the FL-100 and filling it again. You can do this before your spouse files a response to the divorce, but if your spouse already filed, you will need the judge's permission to amend. In addition to identifying the issues in your divorce, the petition asks you for the date of separation. The date of separation is when there is a complete and final break in the marriage, either because one spouse expressed to the other the intent to end the marriage, or the conduct of the spouse is consistent with the intent to end the marriage. Okay, the date of separation is important. Your earnings and debts you incur after the date of separation are yours and not shared with your spouse. You may have a very obvious date of separation, or it might be hard to figure out. You went back and forth to counseling, had a huge fight, but then made up, never really had the divorce talk, or no one has moved out yet. Depending on your case, the date of separation may not have a real impact on your case, so it may not be important to figure out. No assets were received or debts incurred after the date of separation, so there's no impact on the division of property. Others, they received significant property or incurred huge debts after the separation date, so it will be important. If you cannot agree to the date of separation and it does impact the asset division, the court will look closely at the facts to decide the date, such as, when did one spouse move out of the family home? When did you stop marriage counseling? And whether you had conversations about ending your marriage or some significant event, like a huge fight that ended the marriage. You can use the same rubric the court uses to reach an agreement with your spouse. If you are unsure, you do not need to put a date. If you do put a date of separation on your petition, and you later change your mind about the date, you can change it with the final divorce papers or amend your petition.